The following program is recorded with a 5-second delay. In the event of something truly horrific happening, the host has 5 seconds to calmly interrupt the flow of the stream and prevent the content from reaching your sensitive eyes and ears. Alas, the host has absolutely no clue whatsoever which buttons need pressing to abruptly halt the stream, so he will likely spend those precious moments screaming, "Oh my God, no, how could this have happened? Holy hell, oh my God, no, 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 why didn't I figure out how to fix? I knew this would happen, oh my God, I suck, damn it, damn it, damn it." Good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, a.k.a. Good Lawgic. Not going to kid you. Dealing with some issues backstage here. First and foremost, first issue I'm dealing with is that all my players who are supposed to come in here, so far, backstage, I have one who just popped in a second ago. Just popped in like literally as I was saying this. And frankly, one is enough, I think, for tonight. I only really just need one guy with me. So I'm going to actually bring him on up here right now as he came in here. Hopefully his audio is going well. So we're going to start with this. I'm going to introduce you all to a guy who I think has been on here as a player in the past, and that is Kevin. Kevin.
Hey,
Kevin. Hey,
Joe.
How are you?
I'm good, man. How are you doing?
Are you ready to do a live read with me tonight?
I am ready.
Oh, that's awesome. What do you have any Southern background?
Southern? No, I'm a New Yorker. So no.
All right, because his counsel is Roy Barnes. I could use another person. If someone in the back wants to if someone else wants to jump in, I could use another person. And if you're Southern, that's a plus. That's a plus because his counsel is a pair of Southerners, one of them being former Georgia Governor Roy Barnes, who actually testified at the Fani Wade hearing that we had back in the beginning of the year. So that would be amazing if I can actually get someone who just says, "Hey, Joe, I'm send me up like a DM at the following pro on X, and I could just drop you a link." That'd be amazing. But if not, we'll be able to swing it through. I think we'll be fine. Anyway, so that's first things first. I did promise on X. One of the things I promised is that there's a video from Harry Enton where he's analyzing how things are really not so terrible for Kamala. And I want to just break down exactly how comically stupid his assessment is and how transparent it is as to how desperate he is to try and find some sort of sliver of light, and just the obvious lie that he drops on his own audience there, which is just awesome. But I'm just going to break that down for you all. But before I do that, I should call to you all. This is the video, by the way, I'm talking about, in case you want to. This is the video right over here. Is the video that it's a short 3-minute video that we're going to watch together. But I should call attention to Master Phillips bringing in 5 new members of the following. Welcome to the following. Who do you bring on board here? I need to see who you brought on here. Who'd you bring on in? Of the following. Welcome. That's an echo. We had Denise, Wally Lost, Kelly R., Michael Zippo, and Cat Mama, all of them gifted memberships courtesy of leader number 7. That's right, King of Recruitment. Master Fellows bringing in another 5 members. Thank you. God bless you. Those of you who are new members to the following, I appreciate if you could just extend your gratitude to Master Phillips, King of Recruitment, and leader number 7. God bless you. And remember that the following is I am not the leader. of the following. I'm just a host. I'm just a host. Just Dawn says, just Rhonda is a complete rock star. She's emailed you emojis for channel members. I believe there's a big loud horn of some sort. A big, she has. I did get them. I haven't been able to implement them yet, but in honor of her efforts on that, I'm definitely appreciative of it. I'm going to drop for just Rhonda. Can you hear those horns when I drop them, or you don't hear them?
I hear them.
Oh, you do?
Mm-hmm.
Oh, all the better. Good. All right. So let me break down this video real quick, and then we're going to jump on in to the deposition. If anyone does want to jump on, if anyone wants to jump in, and especially if you're a Southerner, but you don't have to be. If you want to jump on in here and play the role of his counsel, that would be amazing. Really could be guy or gal, I don't care. But a Southern accent would be preferable. So, and if not, if you don't have a Southern accent, I don't care. I really could just use a third person here, because the way I'd like to structure it is have the questions are all blacked out. If you haven't looked at it all at the deposition, you probably haven't yet, Kevin, right?
I just opened it. I didn't look much.
Right. Well, I'll be sharing the screen with you anyway. You don't need to have it there with you.
Okay.
But so that's not essential. But the questioners are all blacked out, so we don't know which members of the House are asking the questions. But the names of his counsel are there. He actually has two counsel, one of them being Roy Barnes, another being, I think, Evan Clark or something like that. So they're both his counsel. And we'll talk a little bit about why it's so interesting that Roy Barnes is representing him in a moment. But yeah, so if we can have one person for Wade, one person asking questions, another person interjecting on behalf of his counsel whenever they interject, I think that probably would make it run a little bit more smoothly. But look at this. Look at this. Look at this. Steven.
Hello.
Hey.
I
How are you?
stole the link from locals. Beautiful.
That's awesome. Do you have a Southern accent?
No.
Can you fake it?
Can't do accents.
Can you fake it?
No.
All right. Well, let me just cover this thing with Harry Enton real fast.
Definitely.
I'm glad you stole that link. It was a good job on your part. So this link that I wanted to show, where are you? Yeah, look at this. Maybe you guys can identify it. We'll see if you can figure it out right away. We're not going to go through probably the whole video. We'll see if you guys can figure this out. Here's Harry Enton trying to reassure his CNN following that things are not quite as bleak. Well, that's weird. I'm hearing feedback. Things are not quite as bleak for Kamala Harris as everyone would have you believe. Check this out.
Because we've seen.
Whoa, you're not going to hear that. We need to make that a little louder. Let's make that a lot louder. Let's make that a lot louder.
In so many groups this year moving in Donald Trump's direction. So you would think his core group, his base of support would be doing the same. But in fact, it's moving a little bit away from him. So this is Trump's margin with non-college white voters. Unlike most voting blocks, this group is not moving towards him. It's actually moving slightly away. So you go back 8 years ago, he won him by 33. You go back 4 years ago, he won him by 31. Now what we look is we see that in the latest average of polls, he's only up by 27. Now, that may not seem like a lot, but given that we're seeing these double-digit gains, say, among black voters or among Hispanic voters in some of the polls, the fact that we're seeing this core group of supporters actually moving away from him, not just off of the 2016 baseline, but the 2020 baseline as well, I think that's a rather interesting development.
Shrinkage, as Donald Trump might say, based on what he said the last few.
It's so desperate to try and knock him with a little shrinkage reference there from the king of shrinkage right there, John Berman.
Days. Why could even a small
John Berman, in case you're wondering, here's a little interesting fact. He's the first person I ever identified as a gino. And that's only because he did a whole retrospective on his own personal life where he found out that his family are literally Jewish bastards. Like that's like under Jewish law, they're Jewish bastards. And he was taking up his umbrage against MTG for saying something about the passport that they had down back in the 2020 issues that I don't want to really be more specific about, but that she said that that's kind of like the Jewish star. And he was personally affronted by it because he's such a hardcore Jewy Jew. So he put on his big his big cape there with the letter J on his chest to remind everyone I am Jewish. And I was like, this dude literally did a retrospective showing that he's like not even allowed to marry a Jew because he's that little Jew. That's that little Jew. I don't even. This is someone who's not going to realize that I'm Jewish is going to think that this is like the most anti-Semitic rant I've ever done. All right. Anyway, I don't want to get into John Berman here, but
No
let's
one's going to
go.
not realize that.
You think? Wait. What does that mean?
We all know at this point. It's not a secret. Sorry.
Difference with this group matter.
Why can a small difference with this group matter? Because look at what percentage of the electorate that they make up. So we can look nationally, right? Look at this. Non-college white voters make up 40%.
By the way, he's looking at his card because that was a question he was supposed to ask, so that Harry Enton can go to the next card as to why this is significant. So this way they had their dialogue back and forth. And he can't remember a question that he has to ask 5 minutes later, which is why he has it on his little card there. Why is this? And why does this matter?
And the electorate, that's more than college whites at 29%. All other groups, voters of color at 28%. So this is something that we've seen throughout the board, right? Which is that Donald Trump is making huge gains with groups that make up a smaller percentage of the electorate while he's losing a little bit. But these groups that he's losing a little bit of make up a much larger portion of the electorate. But more than that, we're talking about the US of A where they make up 40%. Why don't you go to those key Great Lake battleground states, Michigan, Pennsylvania, Wisconsin? They have outsized import in those Great Lake battleground states.
Okay, have you yet identified the flaw in what he's saying here, by the way? I know it's the sort of thing I tend to zero in. I don't want to put you on a spot here. You came in here as a courtesy. I appreciate that. The flaw here is this. The flaw here is what is he comparing? He's comparing the results of the November 2016 election and the results of the 2020 election with polling in the 2024 election. That's what he's comparing. He doesn't show us what the polling was in 2016, in October of 2016. He doesn't show us the polling in October of 2020, because I'm sure the polling showed that he probably had a 24-point lead or a 22-point lead, and he ended up coming in with a 33-point lead. So now he wants to try and get his viewers to take heart and say, oh, don't look at this. He's just making gains. He's losing his support in his core over here because he's only polling at 27%. How the hell are the actual results from November of 2016 and 2020 relevant when we know how bad the polling is and how badly they slash him in these polls? How the heck is that remotely relevant? Why would you not show a comparison? Why would he not go back and say, hey, let's look at his polling from October of 2016 in this group? Why wouldn't he do that? Why wouldn't he show his polling from October of 2020? He doesn't show us that. He shows us the results. You want to know why? Because the polling back then, similar to today, the polling back then almost certainly showed that he had less than 27-point lead, but the polling always underrates exactly how well he's going to do with every demographic, including with non-college white people. So that's why he shows us this, and he's trying to gaslight his audience into believing that this is really significant. Oh my God, even though it's a small shift, there are big numbers here, big numbers are coming. And it's like, dude, you're so transparent. You're such a hack. You're so desperate to try and find some silver lining. When I can promise you, you want to know how I know that his polling was better, is better today in October than 2024 than it was in 2020 or in October of 2016 with this specific demographic? Because if it wasn't better, he would show it to us. If he was polling with a 33-point lead in 2016 or 30-point lead in 2016, in October 2016, they would show that to us. He's not showing it to us. Why? It's because he wasn't polling anywhere near as well as he ended up finishing. Much as in this election, we can certainly anticipate that he's not polling nearly as well as he's anticipated to do. And that's why the overall aggregate numbers his numbers are much higher right now, much higher in all these battleground states. We got all these white people. It's unbelievable. It's really unbelievable. Anyway, are you back? Are you good? You good? brother?
Yes, I'm good. Sorry.
You're good, okay.
I was double
This
muted.
is Steven. This is Steven over here. This is your first time on, Steven?
Yes.
Welcome aboard.
Thanks.
Welcome aboard. Anyway, so I just wanted to show that to you as to how deceptive legacy media is, because this is clearly a deception that they're trying to gaslight their viewers into thinking things are not nearly as bad as they are. But they are thankfully, thank God, they're really, really bad. Did you guys see that whole McDonald's story?
Yeah.
Yeah.
It's like newsflash. Trump didn't really apply to work at McDonald's. Oh my God.
Well, first of all, I think it was great PR. I think it was great PR because now they're sitting here trying to figure out how can we try and twist this back at him as if like this is egg on his face that he didn't actually really apply to work at a real McDonald's. Oh my God.
How dare they screen the people before they go up to the drive-thru?
Yeah.
How could it possibly be that the camera crew just happened to be there when he was really at a shift?
Yeah.
The picture with them hanging out the window is the best.
And they really think this is like a gotcha. At least some of the idiots on Twitter think this is a liar.
Yeah. Anyway, I want to get your names up here because I want people to be able to. Let me see how I do. There's a way I can do it. I got to remember how to do my settings here. Settings, general. No. Oh, shit videos. I never remember how to do this. Virtual background, audio, camera. Layouts. Damn it. Sorry, I really wanted your names up here. Well, anyway, to my right over here is, or I guess it's my left. Yeah, when you're looking at it, it's okay. Well, to my left is Kevin, and below is Steven. And they are the players for tonight, and they're going to be joining me in doing a live read of the Nathan Wade deposition that we're going to get to presently. Let me just get to these two super chats real quick, and then we're going to jump on in and start tackling this deposition. You guys can start jockeying with each other for position on which of you wants to be, on what roles you all want. Just to make US aware, today in UK, a mean political prisoner was found unalived, run and fight against socialism. Wow. A mean political prisoner was basically butchered in jail. Nice. Yeah. This is the world. This is what the left wants to turn America into. Wow, it's called. Can you pull a picture of Zuckerberg, please? Don't know what that means. I don't know what that means, but all right, brother. Okay, let's get on into it. I'm gonna pull this up here. Where are you? I'm gonna pull it up. We're gonna make it a size that makes sure that you guys can all see. Why don't I see it here? Oh, I'm in the wrong place. Okay. Okay. This here is the deposition from October 15th. It was held in room 2237, Rayburn House office. And appearances, look at what they did here. They blacked out everyone here. So we have no idea who's asking questions. But those are the people for the Committee on the Judiciary, which is being run by the Republicans. Apparently some minority representatives were in there. I'm sure that there were certain congressmen or women who were there. Excuse me. And the witness, these are the two attorneys for the witness. We have Roy Barnes and Andrew Evans. So what we're going to have here is a whole bunch of, you see, blacked out. We don't even know who this is. When we see a blackout, we can assume it's some member of the House. So one of us is going to have to be handling members of the House. I think it's probably best if I do the members of the House. And now do any of you have a preference on playing the role of Nathan Wade? Are either of you really good at seeming like you don't remember anything?
No.
Do you have a particular skill in seeming like you're out in space?
I could play Nathan Wade as done by Little Woody.
All right. Oh, that's perfect. That's perfect. That'd be great. That'd be great. And so in that case,
Barnes.
You're going to play Barnes and Evans. So when you see Barnes or Evans,
I'll argue with myself later on.
Well, no, Barnes and Evans are both his attorneys.
Yeah, but they go back and forth.
Do they?
With each other, yeah.
Oh, you're well prepped here. All right.
I started listening to Gouveia earlier, but I didn't make it all the way through.
All right, here we go. Good morning. This is Deposition Nathan Wade, former Special Prosecutor, Fulton County District Attorney's Office. Chairman Jordan has requested this deposition as part of the committee's oversight of politically motivated prosecutions by state and local officials, as well as Fulton County District Attorney's Office receipt and use of federal grant funds. So they got two different things they're covering here. Number one is we want to see if they're being politically persecuting people. The other is, we know that there's a lot of shenanigans going on with the way they handle funds in Fulton County, and we want to find out more about that to the extent that he knows about that. I don't think he would know much about that. But on September 20th, the chairman authorized the first deposition subpoena. They go back and forth in the whole history here. We don't care about that. That's not really the point. Is you're all here today. I probably should have said this at the top. My name is Black Line. I'm a staffer with Chairman Jordan's staff, the House Judiciary Committee. I'll have other staffers here in the room introduce themselves, starting with my colleague, blank, blank, blank. See, I have the House Judiciary Committee, someone from the House Judiciary Committee, someone with Ranking Member Nadler. I assume these are attorneys. I don't know what's happening here with when they say with, instead of just saying that they're identifying them as actually being Congress people. They're very, very confusing. But let's get on into it. Whenever you see the witness, that's you, Kevin, okay?
Okay.
And just for the record, Mr. Wade, would you please state your name for the record?
Nathan Wade.
Oh, that's pretty good. And you're joined here with two counsels. I'll have them introduce themselves.
Andrew Evans, counsel for Nathan Wade, and Roy Barnes, counsel for Nathan Wade.
All right. You're going to have to try and do two different voices.
I don't know about that.
You can do this, Stephen. I
All
believe you. All right. Anyway, try to talk a little try to talk like Foghorn Leghorn when you're doing Barnes. Okay? Do your best Foghorn Leghorn when you're doing Roy Barnes, because he really does sound a lot like Foghorn Leghorn. Okay? And the other one, I don't know what he sounds like. So
Yeah, I don't know either.
So you could just do your normal voice for that. But do your best if you can. Your best Foghorn Leghorn for him. That'd be perfect. All right. I'll now go over the ground rules guidelines we'll follow during today's deposition. Committee will conduct deposition in accordance with the House regulation for use of deposition authority, and we had sent that around both with September 21st subpoena and the subpoena sent for October 2nd. Regulations incorporated verbatim into the Rules of Committee, Special Rule 11. Our questioning will proceed in rounds. Majority staff will ask questions first for 1 hour. Then minority will have an opportunity to ask questions as well for an hour, to the extent there are members that join us. And if they have questions for you, they'll be propounded during their respective sides rounds. So if a Republican member comes on in, that member will use time that's allotted for us. Democrat member, they're going to go during the Democrat portion. Clock will stop if the witness needs to confer with counsel, when counsel for the witness is speaking, and when members of the opposite side are speaking, we'll stop the clock. We will alternate back and forth hour to hour until there are no more questions and deposition is over. We ordinarily take a short break. And if you want to take a break, if you like to take a break apart from that, please let us know. This is normal thing that they say in deposition, that they sort of try and give you some sort of time whenever you're having a deposition. And I've conducted many depositions, so this part I can tell you. They usually will say, if there's a question pending, please answer the question before you take a break. So if you at any time you need to take a break, feel free to ask for a break, and we'll provide you with to whatever time you need. If you want to consult with counsel, please advise us, and we'll allow you to step out and talk with your counsel. That's fine too. But if there's a question pending, please make sure you answer that question before you step out. So that's a normal thing that they do. They don't say that here. They just say you can take a break really for any reason. You need to get a granola bar, confer with counsel, use the facilities. That's kind of weird to give them the opportunity to confer with counsel when he's not sure how to answer a question and he doesn't answer that question first. That's a little odd. Whatever you need, you let us know. We'll like to make your experience here as comfortable as possible under the circumstances. Welcome to the White House Hotel, to the Capitol Hill Hotel. And we're going to take good care of you here. Make sure we'll tuck you in all nice and sweet, and you're going to feel real good about this whole experience. We want this to be a positive experience for you, Nathan. All right, so there you go. I'll give you the thank you. As you can see, there's an official. Whoa, we don't want that to happen. As you can see, there's an official House report taking down everything we say, make a written record, so that along these lines, we'll ask you to give verbal response to questions. I'm sure you understand that. Is that correct?
I do.
So the reporter can take down a clear record. Please try to speak clearly, and that's also good so the people at the end of the table can hear. From time to time, got to ask you restate something or somebody didn't hear, and so hopefully you can bear with us on that front. We want you to answer our questions in the most complete and truthful manner possible. If you don't understand one of our questions and need clarification about what we're seeking, please let us know. If you don't know the answer to the question or don't remember, please tell us what you do remember. It's okay to tell us if you learned information from somebody else. Just indicate how you came to learn the information. If there are things that you do not know or can't remember, just say so. Inform us who, to the best of your knowledge, might be able to provide a more complete answer for the committee. By law, you are required to answer questions from Congress truthfully. You understand that?
I do.
This also applies to questions propounded by congressional staffers in a deposition setting like that. Do you understand that?
I do.
Witnesses that knowingly provide false testimony could be subject to criminal prosecution for perjury. Michael Cohen. Oh, sorry, Nathan Wade. This includes, for example, stating that you don't recall something when in fact you do. Do you understand that?
I do.
All right. Now, it's technically true. Lying and saying you don't recall something is technically still perjury. It's just very difficult to prove that the person recalled it at the time he was asked the question. It's really hard to prove. Unless you can show he knew the answer, a week before, and then remember the answer a week later and happened to forget it while he was there with you. But furthermore, by the way, I meant to mention to you all, part of the reason it's so weird that Roy Barnes in particular is here as his counsel, it's not just that he's a former governor, but he was a witness, a fact witness during the proceeding. He was a fact witness because in case you missed some of that proceeding, he was a fact witness because he was someone who was offered the job of special counsel and turned down. And Nathan Wade was supposedly there. So it's very weird to have someone who is a fact witness in the underlying proceeding now coming in and serving as his counsel. Because in theory, Roy Barnes himself might be subpoenaed to testify because he was involved based on what the state has told us. That's what makes it very strange that he's counsel, like really weird. But Reformed Convict says McDonald's, Mickey D's won't hire felons, but we will in tunnels. Yeah, that's good call. Ashley Merchant won her case today. Fannie Willis' office going to get hit with $50,000 plus legal costs. Only way Fannie gets out of it is if Georgia Supreme rules she's exempt from Records Act. Yeah, I saw that. I actually meant to share that. Appreciate you calling that to my attention. I meant to share that. Where was that? That was not here. That was here. Phil Holloway shared that out. We're going to take a quick look at that real quick. This is the decision in Fani Willis. And I meant to call attention to this because I actually live streamed this hearing. So it's just going to pause for a second so you all can see Ashley Merchant getting the win from Judge Krause.
By the time those requests morphed into the subpoena that was served on Fulton County, Ms. Merchant had been educated about what it was she was asking for and how to ask for it more clearly, which again could have all been accomplished had Mr. Bond not had the Ashley Merchant rule.
This is Ashley Merchant this is not about the Trump case specifically, not directly, it's indirectly related to it. In the course of her representation of her client in that Georgia RICO case, she tried asking for records and they wouldn't give it to her, and they wouldn't give it to her. She made requests as was proper she made proper FOIA requests, and they had a hearing about this. And the guy who oversaw her requests, a guy named Bond, his name was Mr. Bond, he admitted that he's like, we follow the rule as to the letter, as to what the rule says, not really the spirit of it. We follow to the letter, and I don't like her. So we were kind of difficult with her. Normally we would follow up. If you don't ask for, he basically said, if you don't ask for exactly the way we label it, we have a right to tell you we don't have it. So even if she calls it she calls it the payment filing, and we call it the payment receipt filing, then we don't have to turn over to. We just say we don't have a payment filing. And that's what they did to her over and over again. And he said that was the Ashley Merchant rule that he decided to apply to her. Normally what they would do is they would go back to the requester and say, we don't have the payment filing, but we have the payment receipt filing. Do you want that instead? But they didn't do that with her, because they had the Ashley Merchant rule, which is, I don't like Ashley Merchant, so I'm going to F her up as much as possible. As long as I'm complying with the law, you can't do anything to me. He stupidly admitted this, thinking that this was some sort of win, and Judge Krause slams the attorney's office for this over here with what she's about to say right now.
Not had the Ashley Merchant rule. And so all of that is to say this. What I'm going to ask for from the merchants is a proposed order that rules in favor, or proposed judgment, I guess it would be, that rules in favor of the merchant law firm in this action.
And that's the whole clip right there. The reason it's significant is because she can get legal fees, which is all the time she's spent trying to get these records. It's probably going to be over $100,000. I hope it's over $100,000. Anyway, so I'm glad you brought that to our attention, Charles. Thank you.
A nice bill for the taxpayers.
Yeah, you know what? It's a nice way of embarrassing.
Yeah, I mean,
her
they
for
deserve
being-
it, but
I'd rather she get it than some of the other stuff they spend money in Fulton County on.
100%.
yes.
100%. And she works like a dog, and she's a relentless pit bull in getting what she wants. So it's not Congress's staffing council asking questions. Yeah, but I think they say that Congress may come in. Look at this guy proposed. Joe Neerman and Mo Green from The Godfather are the same person.
That doesn't end well.
What? How do you get that? How do you get that? This is my club. You don't just come into Vegas and start trying to throw yourself around here. We don't give a damn who you are. I'm not going for no massages, that's for sure.
Yeah, that didn't work well.
All right, let's go forward. Let's move along here, okay? So he understands that he can't lie and claim he doesn't recall something, although we've covered that it's kind of difficult for anyone to actually prove that you're lying when you say don't recall something. But that's technically an act of perjury to lie and say you don't recall, if in fact you do recall. Furthermore, you can't tell half-truths, exclude information necessary to make statements accurate. You're required to provide all information that would make your response truthful. Deliberate failure to disclose information can constitute a false statement or perjury. Do you understand that?
I do.
If there is there any reason you're unable to provide us with truthful answers here today?
No reason.
The reason they ask that is because sometimes they might be on the medication, which affects the memory or something like that. So you sort of want to get that out of the way. Or they might be drunk. They literally could be drunk. So you sort of want to, have taken like recreational drugs or something like that, which might affect their memory. So you sort of want to get that out of the way. So this way they can't come back later on and say, well, I couldn't remember anything because I had, I had 14 beers an hour before I went in there. Okay, the federal rules of evidence, federal rules of criminal civil procedure are not applicable for today's deposition, meaning you can't complain and say not relevant. We can basically ask whatever we want, which is pretty much standard operating issues for a deposition, and all the more so for a deposition that's under subpoena from the House. Under House deposition regulation, a witness attorney may not instruct the witness to refuse to answer a question except to preserve a constitutionally based privilege. The House and the Senate, who don't ordinarily entertain common law privileges. So we don't want to hear your damn attorney-client privilege stuff that would be in other places because we got special rules here. Finally, I'll make a note for the staff here today that the content of what we discuss is confidential. Very confidential. No one should ever know what we discuss here. Ever. Under the House deposition regulation. Under the rules, chairman and the ranking minority member needs to consult for the release of any testimony transcripts, including portions thereof. So this means it's a violation of House Committee rules for us to disclose content deposition prior to the ranking member and the chairman discussing it. I guess they discussed it, which is why we have it here. For this reason, the marked exhibits that we use today will remain with the court reporter so they can go with the official transcript. Before we begin our first round of questions, we will afford the minority and counsel for witness and witness an opportunity to offer any preliminary remarks. Anything from you, Foghorn Leghorn?
Well, before we make preliminary remarks, the common law privileges do apply no matter what the rules say. You cannot force a witness to violate a professional standard of responsibility.
And
there's I don't know that I can do voices.
Don't worry about it.
And there's a U.S. Supreme Court case on that. You guys are aware of the Mazur's case in which John Roberts talks about the common law privileges would still be applicable at a deposition setting. So we would still assert, tell him to refuse to answer certain questions that we felt were covered by privilege.
And to the extent you do, we certainly get the chairman to make a ruling on that, and there's certain things we can do.
You can do it. That's the reason they have judges. But a ruling by the chair would not be sufficient to overcome the instructions I'll give a witness on privilege.
By the way, what Mr. Barnes is saying here is something I would tell. I happen to agree with him that this is the position as his counsel you want to be taking. Go on, Mr. Evans.
And I've read Rule 11 several times in the House rules, and the constitutional objections will be the 10th Amendment, separations of powers. Everything that's not enumerated to the federal government is reserved for the state. So that's where our constitutional objection would lie, in addition to the other grounds.
Okay, well, I mean, we've never dealt with an objection on that ground before, but just so we're all clear, if you're not going to answer questions, there's nothing we can do to make a witness. They sound like they have a lot of teeth here, right? There's nothing we can do to make a witness.
Sure, I understand, but I don't want to mislead after you after you making your statement saying, not tell you exactly what our position is.
Fair enough. And so the way the process would work is we confer with the chairman, get a ruling, advise you of the ruling, give you an opportunity to answer the question after you heard the chairman's ruling. And then from there we could, the committee could proceed to a contempt proceeding.
Sure. Which I'd be entitled to a jury trial in DC. And so.
Well, contempt in the House context.
You can't enforce anything. Do you have a jail?
We're not going to. Actually, they do. They can have a sergeant at arms arrest someone. This is, by the way, what the lawyers call a pissing contest, where they're basically saying, well, what powers and strengths do you have? What could you do about it? So that what we're reading here is a pissing contest. We're not going to put anyone in jail over this. I mean, the House does have inherent contempt.
The only power you have is by criminal contempt, and you're entitled to a jury on criminal contempt. But we need to get.
Well, I mean, we do under the rules have a provision, with a contempt citation. We can go to court on civil route, or the House can proceed via criminal contempt citation.
Sure, both of which are overseen by a federal judge.
Indeed.
Bound by the federal rules of evidence.
This lawyer here, by the way, I assume it's a lawyer for the House. He seems to be quickly backing away. Indeed, we can make a criminal referral.
Sure.
To the Justice Department, or in fact, we could just end up just deciding to do nothing.
You and I are not going to settle it, but I wanted to make sure that I was candid with you, telling you what our position is.
Fair enough.
In the spirit of that, we've largely got categories of questions. For example, biographical questions, which you could ask him that he would be willing to answer. That's not a problem. Questions you mentioned, the service of the subpoena, again, not a problem. You can ask him everything like that. But then there's categories of questions, like conversations you may have had with certain House committees, or something that would cite privilege based on attorney work product confidentiality. That's largely what we're going to. Is that we've kind of put these other categories of things for the objection.
Right. And so I hope we can work through some of those, because to the extent they work communications with other House committees, if you're not going to provide content of those communications, we would hope that you would provide the data and the individuals involved, because that certainly wouldn't be protected by privilege.
Well, I don't want to do anything to jeopardize the privilege, so I want to provide that. But there are public records of dates with meetings and stuff that you guys have, invoices submitted, and stuff that give you a lot of the information you're already asking for.
Right. But just so we understand, I mean, if we're talking about communication as privilege, the fact that communication occurred is not privilege. The fact that a person A spoke to person B, and that at the level of privilege log would be entitled to that information. I don't know why they're having this whole stupid conversation. This is the sort of thing you just sort of just jump in and cross that bridge when you come to it.
All right.
Any other additional opening remarks? I know there was some letters exchanged. Do you have any interest in making those part of the record?
They're going to be part of the record. We've marked them.
Can I make? Of course, yeah. It'll only take me 2 seconds. It's always good to be reminded that we don't have a jail in the House. So I just wanted to make a couple of notes for the record. First of all, thank the witness for joining us. Especially, I understand that you have a hurt ankle, so thank you for traveling up here with an injury, among other things. Buzzer just went off, and I think everyone kind of perked up. That's just the House bell. That's proceeding on the House floor, so I think they're probably done for the day. And then I want to make a couple of notes. We continue to have concerns about the videotaping of these proceedings, primarily because there's not been copies provided to the Democrat staff or members. I understand we're going to go view them in the majority's office suite, but that's not the same, especially with how members not here because of, well, especially with members not here because of the recess. And when we are provided with copies to have and hold, it's usually 24 hours before release, which is not really enough time. So now this is obviously the minority saying that's not true. I mean, you get a week. If we're going to release any video, we give it to you 1 week before we put it out. We've had a number of instances where we got them the day before. That's inaccurate. That's inaccurate. We can go back to check the record. I'd still argue that week is not. They've been careful with the video. I mean, the video, the argument, the agreement is, I appreciate you want to talk over me, but can I please finish my statement? I'm not trying to talk over you. I'm just trying to, you're literally talking over me. So if I can finish my statement, and then I'll give you the time back. Sound good? So we continue to have concerns with video. You also seem to have concerns with transcripts. I think there have been something like 135 depositions and transcribed interviews to date. Vast majority have not been released. This is the Democrats talking now. They're complaining. Vast majority have not been released, including depositions, transcribed interviews dating to February, March, and April 2023. So that's over a year ago at this point. For the transcripts that have been released, a number of them have not been included. Have not included most of them, barring those that included in the Joint Oversight Committee, have not included exhibits, which is the transcripts in our minds are not actually final if they're not including exhibits and they don't include errata, corrected errata. So thank you. Errata is a great word. As far as the transcripts go, we release transcripts once the matter is concluded. I really want to get past all this crap. Honestly, I'm not going to kid you. I'm so tired of I just want to get to the questions. I really want to, let me jump on down. Let's
just Democrats complaining. We get it.
Yeah. Okay. Let's get to where the witness is talking. That's what we've done other depositions, whether we're either the witness minority or the deposition transcripts are ready to go almost immediately. Okay.
Yeah, this is all talking about reviewing the transcript before it gets released.
Let's get to the witness here.
So question, just point of clarification.
Of course.
Prior to the release of the transcript, my counsel will have the opportunity to review it before it's released?
Of course.
Now, tell me what release means. Where does it go?
Normally, we put it on our website. Now, if there's anything in the transcript you don't want released, you can tell us that you would seek a redaction, and we would consider the request. Sometimes we're able to honor it. Sometimes we're not. If it's personal information, we ordinarily honor that type of thing. Like if there's specific addresses or that type of thing, we would ordinarily honor that type of request. All right, they're going back and forth here with all these other stupid things. I really want to get to the actual questions. Do you have any more questions? Do you have an opening statement you'd like to offer?
I do. Good morning. My name is Nathan Wade. I'm a licensed attorney in good standing in the state of Georgia. I am here after voluntarily accepting service of a subpoena from the House of Representatives of Congress of the United States of America. I am here of my own volition, having paid for my own flight tickets and hotel room in an effort to respond to any legal relevant inquiry. Please note all arrangements were made per agreement from my voluntary testimony to take place back in July, but this committee changed that date for its own convenience. You are aware I served as Special Assistant District Attorney in the case of the state of Georgia versus Donald Trump et al. Indictment number 23 SC 188947 in the Fulton County Superior Court.
Sorry.
Prior to accepting the appointment as Special Assistant District Attorney for the Office of the District Attorney of Fulton County, I served as a prosecutor several times during my career. First as an Assistant Solicitor General in Cobb County, Georgia, then as a Special Assistant Attorney General for the state of Georgia. I began my private practice in 2000, where I served as a criminal defense attorney representing hundreds of individuals in state and federal courts charged with felony and misdemeanor offenses. I've tried many felony cases representing clients in serious matters, including but not limited to capital offenses, murder, armed robbery, aggravated assault, and drug trafficking. Many of these cases garnered media attention. I've served as a civil attorney in private practice representing individuals, businesses, and corporations alike with no attention given to partisan politics. I've previously been retained to represent a Republican sheriff. I've served as legal counsel to the Cobb County branch of the NAACP. In 2010, I began serving as a municipal court judge in several cities in the state of Georgia and was proud to have become the first African American to do so in the city of Marietta, Georgia. I was invited to assist in the training of newly appointed municipal court judges and did so with great pleasure. I've received dozens of accolades and statewide recognitions over the course of my legal career. My team and I investigated the issues in the election interference case for more than 2 years. This case was not politically motivated.
Not at all.
Not at all. Rather, it was an independent investigation based upon facts, interviews, evidence, and the rule of law. I had no mandate other than to honestly seek the truth.
Honestly.
I was never directed, ordered, asked, coerced, or pressured to bring any charges against anyone. I don't even know who that would mean. I took my oath as a special prosecutor with a solemn pride and responsibility. I did not violate that oath and did nothing to compromise the integrity of the Fulton County indictment alleging interference in the 2020 presidential election. No one at the White House counsel's office, the Department of Justice, or the January 6th committee directed, ordered, asked, coerced, or pressured me or any member of my investigative team to seek or not to seek an indictment against anyone, whoever that might mean. Due to the lack of cooperation from witnesses and government officials, the Fulton County District Attorney requested permission from the Fulton County Superior Court judges to impanel a special grand jury to investigate the complaints surrounding the 2020 election. The special purpose grand jury returned an exhaustive report recommending indictments on a host of individuals, many of which were not named in the pending charging document. Following the recommendation, a Fulton County grand jury returned an indictment against all individuals named in 23 SC 188947, respectively. Several defendants moved to disqualify the district attorney of Fulton County and myself from the prosecution of this case. The trial court held a hearing during which I testified and was cross-examined 4 hours by defense lawyers. In March of this year, the motion to disqualify was denied.
Perjury! That's not true. That's not true. He was forced to leave. This is perjury right here. This is perjury. It wasn't completely denied. It was in part denied. It was in part granted. So this is perjury. But,
I can't even get through an opening statement without lying.
yeah.
In its distasteful dicta, the court opined that I either resign or the district court.
No, that wasn't dicta. That's not dicta. That was an order from the court. Distasteful dicta. Okay, go on.
No, it's irrelevant stuff on the side, don't you know? The court opined that either I resign or the district attorney's office resign from the prosecution of the election interference case. Consequently, I voluntarily submitted my resignation immediately. Since that date, I have had minimum contact with the office of the district attorney of Fulton County, and I have had no access to documents left there. On May 9th, 2024, I received a letter from this committee on the judiciary requesting that I produce 6 categories of documents. I voluntarily complied with that request by producing all documents that I possessed. I had nothing responsive to categories of documents relating to notes, memoranda, or communications between the Fulton County District Attorney's Office and any other agency. The committee's stated purpose in requesting those documents and in seeking my appearance to date is that the committee is, quote, considering potential legislative reforms. Where is it?
Establishing here.
Okay. Establishing clear guidelines outlining the permissible use of federal grant funds under 34 USC section 10 26.1, whatever.
Creating penalties.
Creating penalties for unlawfully misusing federal grant funds under Title 34 of the United States Code, constructing stringent automatic audit requirements for department grants, managers, or modifying eligibility requirements pertaining to grant recipients that misuse federal funds, close quote. The committee has also, quote, considered legislation broadening the existing statutory right of removal of certain criminal cases from state court to federal court as a remedy against politicized prosecutions by popularly elected state or local prosecutors, close quote. I am here to cooperate, and I welcome all legal and relevant inquiries related to your defined scope. Contrary to any fabricated story that has somehow evaded service of process, I've voluntarily reached out to the U.S. Marshal's Office and suggested a meeting place and time immediately upon being made aware through false inflammatory media reports of Congress's attempts to serve me.
More perjury.
Strike two. You are aware that I am bound by the Georgia rules of professional conduct and responsibility and must at all times maintain in confidence all information gained in the attorney-client relationship. Now, I have been served with the following letter, which will serve as guardrails directing my responses as it relates to certain topics. And I'll read this letter to you and provide this as an exhibit.
That'd be exhibit 2, I guess.
This is a letter sent to myself from the office of the Fulton County District Attorney, Atlanta Judicial Circuit.
I don't know if I want to go through the whole letter here, but basically it's a long letter that Fani wrote, basically saying that she doesn't want him to testify, and so I just want to skip past that part over here. So let me see. This is still this is still part of the letter. Yours in service. Okay. All right, fine. What was the date of that? What exhibit? Well, exhibit 2 is his opening statement. Okay, so exhibit 3 is a letter. Do you have a copy? I didn't get a copy. I don't know if Mr. Wade bought copies. He did read in the record. That's fine. So we're going to mark exhibit 4 with the October 11th letter to Chairman Jordan from the district attorney. We're going to mark as exhibit 5 from the governor on behalf of the district attorney. Do you have a date to that?
No, I don't.
And then exhibit 6 is September 30th letter from the governor to the chairman. I can represent that we received in exhibit 5 via email on September 20th. A couple days after you all did, we did receive it. So exhibit 6 is the letter. All right, let's go forward here. I want to get into the examination.
I don't know if you read that letter, but Barnes said that
he needs
anger management.
Yeah,
classes.
he was kind of like a lunatic. I read it on the air here last week.
Yeah, it was crazy for a ex-governor.
He seems kind of yeah. He wrote that to Jim Jordan, I think.
Yeah,
right?
to Jim Jordan.
Yeah, saying Jim Jordan, you need anger management classes, and then maybe I'll consider responding to you. It was ridiculously disrespectful.
Roy Barnes wrote that?
Yeah.
That's what Roy Barnes wrote to Jim Jordan. Yeah, I just want to pause and say, Wally Lost, God bless you. Hit me with 5 good Lawgic memberships. Let me just call out. Let me do a quick call out here that Wally Lost brought in Evelyn Cox, Awakening Wonder, Wisconsinite, Jonathan Daston, and Audra. All of them gifted memberships to the following. The following is not at all a cult, type of cult, but you are now part of a group of people who are committed towards greater personal growth through community, unity, and leadership training. And we're urging you all to manifest your own personal growth right from the get-go by expressing your gratitude to Wally Lost for that magnificent gift that was bestowed upon you. That'd be courteous. We appreciate that. So didn't Congress break Trump attorney-client privilege under crime fraud exception for January 6th? Yes, they did. Yes, they were very, very. They were very, 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 very aggressive in that. Oh no, politicized prosecution. Yeah, seriously. Except when I go with Big Fanny to pick up daughter in her car, no other contact. Yeah. I know. He's like, I'm not in contact with that office at all. I'm not in contact with that office at all.
I don't go to the office. But
Ah. Well, he doesn't technically work there. To be fair, he was hired as special prosecutor.
yeah, but he doesn't go to the office anymore. But he
just goes when the daughter gets arrested.
He still visits
whatever.
the DA.
Supposedly, their relationship was. They admit that the relationship was resurrected after this decision was issued. I remember seeing something to the effect that their on again, off again relationship is back in the on again stage. At least it was a couple months ago, from what I recall.
It's very convenient for them.
Dear court, please do not prosecute my poor black child for perjury. Signed, Mom. Pretty funny. All right, let's get into the examination. Good morning, Mr. Wade. I want to start off by talking a bit about your professional background. How many years have you been practicing attorney in Georgia?
Since 1999.
And you're still licensed to practice in Georgia, is that correct?
That is correct.
Is that the only jurisdiction you're currently barred in?
Yes, ma'am.
And so it's been about 25 years. Can you provide an overview, which, by the way, that's actually the same year I was admitted, was in 1999. There you go. I graduated in 98 and admitted in 99. Is that the only jurisdiction you're currently barred in? Yes, ma'am. And so it's been about 25 years. Can you provide an overview of the previous positions that you've held?
Okay. Let me refer back to my statement here. I served as a prosecutor several times during my career. First, as an assistant solicitor general in Cobb County, Georgia. Then as a special assistant attorney general in the state of Georgia. I began my private practice in 2000, where I served as a criminal defense attorney, representing hundreds of individuals in state and federal courts, charged with felony and misdemeanor cases. I've tried many felony cases representing clients in serious matters, including but not limited to capital offenses, murder, blank, armed robbery, aggravated assault, and drug trafficking. I have served as a civil attorney in private practice, representing individuals, businesses, and corporations alike. I have previously been retained to represent a Republican sheriff, so I'm not biased. I served as legal counsel to the Cobb County branch of the NAACP. I began serving as municipal court judge in several cities in the state of Georgia and was proud to have become the first African American to do so in the city of Marietta, Georgia.
The first African American to be a traffic cop judge. I don't even believe that's true. Maybe I find it very difficult to believe that's true. You said in 2000 you started private practice. Would that be the law offices of Nathan J. Wade?
Yes, ma'am.
And do you still practice under that moniker, under that name?
I do.
So you said your practice is focused on criminal offenses, but you've also worked on the civil side. Is that correct?
It's not focused on criminal defense, but I've done them both. Yes, ma'am.
If you had to characterize a primary focus for your years of practice, what would that be?
Today, more civil.
More civil. What was in the past? More criminal?
In the past, it has been, yes.
And you're currently just practicing under the law offices of Nathan J. Wade?
Yes, ma'am.
Are you currently employed by any other private law firms?
No, ma'am.
I know where this is going. I think he's going to need clarification on what that means.
Look who we got here. We got a celebrity in here. That's right. Andrew.
Hey, sorry.
How's your foghorn leghorn? How's
I lost control of my.
Andrew? How's
Hey guys.
everyone?
Hey,
this is the esteemed law of self-defense. Andrew Branco, my good friend here.
Hey, I joined because you sent me a link, and I really appreciate it. But you guys are doing an awesome job.
If you want to jump
I
in,
don't-
if your foghorn leghorn is any good at all, I'm gonna urge you to stay and play Roy Barnes.
No, it's not. I'm going to defer to the expertise your current guests are bringing to this. They're doing a fantastic
They're doing great.
job.
No,
Yeah,
you're
it's
right.
amazing.
They're doing great.
So
All right.
I'm very happy to have been invited. Don't get me wrong, but I'm not sure how much I have to contribute. I think,
Yeah.
of course, this entire thing is an utter travesty of justice. It's exactly the way that the legal system should be working if we were all on psychedelics all the time. But unfortunately, this is where we find ourselves. So.
Yeah. All right, Mr. Evans, let's get back to you, Stephen.
I know where this is going. I think he's going to need clarification on what that means.
Do you provide services to any other private law firms?
I am co-counsel at times with cases. With other law firms? Absolutely.
Are you currently under a contract with any other private law firms?
No, ma'am.
Are you in any sort of joint partnership with any other law firms?
No, ma'am.
We're talking about right now?
Correct, sir.
Okay.
Are you contracted to provide any services to any government entities?
Currently, no, ma'am.
When was the last time you were contracted with a government entity to provide services?
As special prosecutor in Fulton County.
And prior to your appointment as special prosecutor of Fulton County, had you been contracted with any other government entity to provide services?
Yes, ma'am.
And which ones were those?
Let's see. As I noted in the opening remarks, the Cobb County Sheriff.
No, that's not government entity. That's not government entity. That's a private guy who hired you for a civil thing. That's ridiculous. That's a joke.
Strike three.
Yeah. Uh-huh.
The city of Marietta as a municipal judge. The city of Roswell as a municipal judge. The city of Austell as a municipal judge.
These are all traffic cops. This is literally like speeding tickets.
By the way, and just a piece of trivia, Marietta, Georgia is the home of Glock, the Glock pistol.
Nice.
Didn't know
All right.
that.
I want to talk with you. You spoke in your opening statement about the various correspondence that you and your counsel have had with the committee. And so we first requested your transcribed interview on May 9th, 2024 via letter. Did you receive the May 9th letter?
Repeat the question, ma'am.
So the committee first requested your voluntary testimony via transcribed interview in a May 9th, 2024 letter. Did you receive that letter?
Is that marked as one of the exhibits?
It's not marked as one of the exhibits. And exhibit number 1, which was a subpoena, includes 2 cover letters. First, the October 2nd one, then the second one is dated September 21st.
Okay.
And I can read from the September 21st letter. The second sentence says, as part of our oversight on May 9th, 2024, the committee requested that you appear for a transcribed interview relating to your work for the Fulton County District Attorney Office. I'm just asking if you remember receiving the May 9th letter.
I don't recall receiving. I do recall receiving a series of letters. I don't recall the dates nor the contents of those letters.
And when did you first seek to schedule your transcribed interview, if you can remember?
I don't recall. That was a communication between my attorney and whomever he was communicating with.
And so originally your transcribed interview was scheduled for late June. As you said in your opening statement, the committee needed to reschedule that. In communications with your counsel, he informed the committee, and I can read from the September 21st letter again.
Sorry. We're bouncing back and forth. A little letter, the May letter, the September letter. This one is a September letter?
This is September 21st, 2024 cover letter. It's part of exhibit number 1.
Okay.
So the first sentence in the second paragraph of September 21st, 2024 letter reads, quote, after 2 months of communications following our May 9th letter between your counsel and committee staff, your counsel informed the committee on July 19th that you agreed to appear voluntarily for a transcribed interview on September 18th. Do you remember being informed that you would be at a transcribed interview on September 18th, 2024?
Vaguely.
That's yes. Had you made any travel arrangements to come here for the September 18th transcribed interview?
Yes.
And you ultimately did not appear on September 18th, 2024 before the committee. Is that correct?
I want to make certain that I'm answering as it relates to the proper letter. There were so many letters back and forth that I don't want to mislead you.
Oh, yes, you very much do.
So let me be clear. The preparation to come for the July timeframe, that was agreed upon. I did prepare to do that.
Uh-huh.
I believe that was the question you just asked me, right?
I asked about your September 18th transcribed interview. The reschedule
Very
of
sexy, Joe.
transcribed interview for September 18th. Did you make any travel arrangements for the transcribed interview?
For September the 18th?
Yes, for Christ. That's correct.
Nah.
And you ultimately did not attend the transcribed interview on September 18th. Is that correct?
Is that the subpoena that I was given on that date?
No, sir. If you look at the September 21st, 2024 letter, which is part of exhibit number 1, I believe it's page 3 of exhibit number 1.
I don't have a September.
This one.
That says October 2nd.
So here's the September 21st, 2024 letter. I'm specifically looking at the second paragraph. It starts, after 2 months of communications following our May 9th letter between your counsel and committee staff, your counsel informed the committee on July 19th that you agreed to appear voluntarily for a transcribed interview on September 18th. In the week preceding the scheduled interview, the committee contacted your counsel twice via email, did not receive a response. Instead, on September 13th, just 5 days before your scheduled interview, your counsel informed the committee that due to an unsolicited letter from Roy Barnes, counsel to Fulton County District Attorney Office Fani Willis, you would postpone your appearance. Notably, your counsel offered the committee no alternative dates for your testimony. You just said, go to hell. Finally, on September 17th, your counsel confirmed that you would not appear for your scheduled interview based on concerns raised by the Barnes letter. So in reading that, I go back to the question of, did you appear for your September 18th transcribed interview?
Well, based upon what you just read, it sounds like I was not, that there were ongoing communications and negotiations, and I wasn't required to appear.
Which is crap, because there weren't ongoing communications. It was your counsel saying, F you, we're not showing up. And so, based upon your failure to appear on September 18th, transcribed interview, committee then moved to compulsory process via subpoena. When did you first learn the committee was issuing you a subpoena for your testimony?
I had played in a community basketball league and hairline fractured my ankle. Because of that, I was in and out of orthosurgery centers. I was obviously prescription medication because of the pain and the swelling in my right ankle. And to date, it is still swollen. So at times, I may have to elevate it to keep the swelling down. What the hell is he talking about? But
This is
Not an answer.
This is like basic. This is the dog ate my homework. This is what this is, if you're wondering.
And the book was very good. But I took a few days to take care of my fractured ankle and to prepare for an upcoming mediation and arbitration. When I was able to deal with the pain without the assistance of the prescription pain medications and came to, I turned on my cell phone and prepared to go and exercise down in my exercise room.
So apparently when he's dealing with pain, he has to turn his cell phone off for like weeks at a time.
Yeah,
When is a briar patch showing up?
He has to come to. He was completely out of it that entire
Oh my
time.
God.
I mean, to be fair, dodging a subpoena is probably a major pain.
And then he goes straight to exercise.
Yeah.
And when I did that, messages started to ring through. And one of the messages was from a U.S. Marshal identifying himself and leaving a phone number. I called that gentleman back. And
you know, it's a bad sign when the U.S. Marshal calls you. That's never good.
Yeah, it's never. Yeah, that doesn't end well.
Yeah, the voicemail from the FBI.
And at this point, it's 4 a.m. because I rise at 4 a.m. to do my exercise regimen. He answered the phone. And I said to him, I understand that apparently I am missing. I've seen reports that no one can find Nathan Wade. I'm here. Who's looking for me? The marshal then said to me, sir, that is ridiculous. We know that you're not trying to hide or evade service.
We know you're not invisible.
Oh. We know that, obviously.
We know you have a corporal presence, sir. We're trying to secure your body in a cage.
We know you don't understand object permanence yet. And I said, what service? And he said, I have something here to serve upon you from Congress. And I said, I tell you what, I can meet you now, or we can designate a time and a place. And he said, no problem. He said, but that subpoena was for today. He said, I don't think I'll need to serve that upon you, but let me get some clarification. I'll call you back. We hung up the phone. Approximately 8:39 a.m. He called me back. He said, Mr. Wade, I need to go ahead and leave those papers with you. Where are you going to be and what time you going to be there? I said, I tell you, I'll meet you at my office. I hadn't been to my office in quite some time. Over a week I hadn't been there. I'll be there and I'll meet you. And you can give me what you need to give me. He said, thank you. We hung up the phone. Maybe 45 minutes to an hour later, he walks through the door shook my hand, handed me the documents, and walked away.
This guy is such a bad liar. He's so stupid, and he thinks like this is like compelling. This is like such a compelling story.
By the way,
And
your narration is fantastic. I feel like I'm listening to 50 Shades of Fani Willis.
He's
It's
great.
amazing.
He does a really you do a really good Nathan Wade. Seriously, Kevin, it's a really good. It seems practiced. I'm glad you grabbed the part. You're handling it perfectly.
Oh, thank you.
And when your attorney authorized to accept service subpoena on your behalf of the committee,
I hadn't spoken to my attorney at that point.
but previous to the subpoena,
Nope. We had no conversation about him accepting anything on my behalf.
so you said that you had never spoken to your attorney about accepting service on your behalf. Is that correct?
We had no conversation about him accepting service of any kind on my behalf.
On September 21st, as Blank noted in his opening remarks, he emailed you a copy of the subpoena. Did you receive that email?
Who emailed me?
I don't know. Oh, sorry.
oh.
Blank did.
I don't know. I don't recall receiving an email, but if he said it, I'm sure that he did. He seems to be an honest man.
Are you aware that on the same day prior to sending that subpoena, Blank also attempted to send the subpoena to your attorney? Were you aware of that?
No.
Did you have any communication with your attorney on September 28th when the subpoena was authorized? Not looking for content discussion, just yes or no.
Do I have contact with my attorney constantly?
I mean, that goes to a conversation that we've had. I would tell him not to answer the question.
Well, he already did, jackass. We're just looking for whether a conversation occurred, not the content of the conversation, just a yes or no.
Conversations that he has with me are privileged, so I'm going to tell him not to answer that.
That's crap. You can't. There is no privilege on whether or not you communicated. There's just the content thereof. The Evans is pushing the envelope here in a direction that is no legal basis. So, did you have a conversation with your attorney ever about the subpoena? That is content.
Yeah, hang on. Don't answer that. Did we ever have a conversation about the subpoena? Yeah. I mean, I'm going to instruct my client not to answer.
And that's fair. That's content. Did you have any conversations with your attorney on September 20th?
Same objection.
That's not a valid one. On September 21st, just looking for a yes or no, not about the content of the discussion.
Same objection.
On the 23rd?
Same objection.
So on September 23rd, they're so lacking in any sort of teeth, the House here, because they should just tell them, F you and your stupid objections. Because you can't object to a question about whether or not you spoke. You can object to content, but not about whether or not you spoke. On September 23rd, that was the first time that the marshals attempted to serve you in person. Were you aware they attempted to serve you in person September 23rd?
I think I just shared with you an experience where I voluntarily reached out to the marshals and they served me in person.
By the way, when he called them at 4 a.m, he did not expect them to answer the phone. That's why he called at 4 a.m. You call at 4 a.m. so you can pretend I'm trying to be helpful here. He was shocked when the dude answered the phone at 4 a.m. He was.
Can you
shocked
imagine
and
the guy,
disappointed,
the marshal?
and disappointed.
You think the marshal was sitting there at the phone saying, "This motherfucker is not expecting me to answer the phone"?
Yeah. That's totally
I'm gonna wait
happened.
here. I will
That's
wait
totally
here
what
for a
happened.
week. I'm gonna grab that the moment it rang.
Yeah.
Bam! Grab that.
He
phone.
had the phone by his pillow there, and like as soon as it
Hello?
rang, he saw Nathan Wade's number. He's like, "Hello."
And that was me.
Gotcha, bitch.
Exactly. So now Nathan's like, I'm trying to do everything I can. 4 a.m, I turn my phone on. Yeah, what do you want me to do? So your testimony is that you turn your phone off because you had fractured your ankle. Is that correct, sir?
No, ma'am. My testimony was I turned my phone off to prepare for an arbitration and mediation that was upcoming, along with nurse my ankle back to health. So I sort of,
So that's a yes.
when I get into trial mode, when I'm preparing for trial
mode.
I shut the world off. My job is to handle my client's business, and I don't want any outside interference. So I had no contact with anyone during the course of that preparation.
So full of crap. So what date did you turn your phone off?
I turned it off. The exact date, I can't recall. I'd give it to you if I could. I can't recall the exact date.
So did the phone, if we request your phone records, September 20th to September 26th, will we find that your phone was off? You had no communications by your cell phone?
I don't know what date it was when I shut it off, but during the course of that period, you will find no communications because the phone was off.
Yeah, for like 2 hours a night. Probably when he was like visiting Fani. And
Didn't
so
wanna
what
be
happened
tracked.
first?
When he didn't want to be tracked. That's when. his
Yeah,
phone was
exactly.
off.
Yeah.
By
When
the way,
when he
I
was driving
apologize.
Fanny's house.
I'm sorry, Joe, but the other two gentlemen here, I didn't introduce myself. I'm Andrew, but I don't know your names actually. So could you introduce yourselves? I mean,
Yeah, I'm good to meet you, Andrew. I'm Kevin. Big fan.
Kevin and
Steven.
Stephen. Are you guys lawyers?
Nope.
No.
No.
Okay,
Top
that's fine.
45.
It's fine. I just want to know for context purposes.
Yeah, no, they're part of my rotating Good Logic players staff.
Yeah, doing a great job.
And they're
Fantastic. I'm really
phenomenal.
enjoying this.
Good.
Oh, thank you,
Yeah.
man.
So what happened first? The phone being turned off, or you hurting your ankle?
The ankle injury occurred first.
Okay, and so between that time, you said that you turned your phone on then at 4 a.m. on September 26th, and that's when you received the messages from the marshals. Is that correct, or do I have the timeline mixed up?
I don't recall. I do recall the marshal saying to me, "This subpoena that I am to serve you is for today's date." So whatever that date was, that's the date I turned my phone on and returned that phone call.
So on the second attempt to serve the subpoena in person on September 24th, the marshals spoke to a work crew that was doing some landscaping work at your house. Are you aware of those conversations that occurred?
You're referring to the second? What's the first attempt?
So the marshals made several attempts to serve Mr. Wade the subpoena.
In person?
In person, that's correct.
When was the first attempt?
First attempt was on the 23rd, which is that Monday.
And the second attempt was when?
On the 24th, which is Tuesday.
Okay.
So on the 24th is the date that they spoke with you. The individual is doing landscaping around your house. Are you aware that they spoke to those individuals?
No. And I'm shocked that the marshals never mentioned to me that they had come to my home. And I had no conversation with anyone doing any landscaping around my property at that time either.
And on September 24th, they also attempt to serve you in person in your law office. Are you aware of that?
I am not. During the course of that conversation, the marshal did say to me that he stopped by my law office, and the paralegal or receptionist told him that I was not there.
And the marshals represented to the committee that the paralegal told the marshals that you were out of town until October 2nd. Is that an accurate statement? Were you out of town until October 2nd?
I don't know what they would have shared with them. I don't know.
And then you said at 4 a.m. on the 26th, you reached back out to the marshals. Is that correct?
I did.
And you did that via phone call?
I did.
And then you accepted service on the 26th?
On that date?
On that morning?
Whatever the morning was, yes.
And then on October 2nd, the committee issued another subpoena. You subsequently accepted service of that subpoena. Is that correct?
So because at this point, I had contact with the marshal via cell phone. That same gentleman called me and he said, "Mr. Wade, I have another document for you. How can I get it to you?"
Uh-huh.
I said, "Well, when do you want to get it to me?" And he said, "As soon as possible." I told him at that point that I'm on my way to court. "You can meet me at the courthouse if you like. Here's where I'm going, and here's the time I'll be there." And he said, "I will show up there, and I will hand you the documents." And he did that.
Okay, and now I want to pivot to talking about your appointment as special prosecutor for the Fulton County District Attorney Office. Who contacted you first about the special prosecutor position?
So this is an interesting story or series of events, how this came about. And forgive me, Governor Barnes, I'm going to have to tell on you here.
That's fine. You won't be the first.
Ah,
This is where it's going to get weird because Barnes was involved in all that.
Yeah,
That's why I
witness.
said it's so
he's
weird.
a witness and a lawyer. This
Yeah.
doesn't make any sense.
Yeah, like he could be subpoenaed by the House also. That's what makes his serving as attorney for Wade bizarre.
This whole thing's bizarre. Anyway,
Mhm.
I was part of a search committee, if you will, for the then newly elected district attorney.
Okay, and you can provide dates for when you were part of the search committee?
Oh, God, I cannot. I'm sorry.
Okay. If it's helpful, DA Willis came into the office on January 1st of 2021. Is that a helpful time frame?
It is. So January 1st, I was a part of the search committee for that newly elected district attorney. and we were tasked with trying to identify someone who would serve as the lead counsel on the election interference investigation. The goal, or the trick, was to make certain that the individual selected or identified was one who had no axe to grind, if you will, one who would be able to be objective and follow wherever the investigative process would lead them. There were between 3 and 5 candidates that we spoke with, a few of which I cannot recall, but there were a multitude of individuals who were reaching out and sending resumes trying to obtain the position. One individual that we did speak with is in the room this morning, and that is Governor Barnes. He, I guess, artfully bowed out of accepting the position of special prosecutor, and he would cite to safety reasons. He would cite to the low financial compensation that Fulton County would offer, and he would cite to a busy law practice that he couldn't afford to devote the necessary amount of time that a case like this would need. Interestingly enough, he also shared with us at that time that he had no interest in traveling in a caravan of security constantly. Now, I should have taken the hint when he said that. I did not. I didn't understand what he understood at the time, apparently. I had no clue that I would need security for accepting that position. But at any rate, he was the one that turned the position down. Other people turned it down. Eventually, I guess the committee turned their guns on me and started trying to convince me to accept the role. I said no.
With him screaming, me.
No. I said no more than once. No. But at some point, I relented and accepted the case because it did pose some interesting legal issues. It was unlike any concept or anything that I had ever dealt with or anybody else ever.
Yeah, it's totally out of his wheelhouse whatsoever. Yeah, that's part of the issue here.
Yeah, having jurisdiction over a president. Most people haven't.
No, but it's also that he's never been a
wiping his
prosecutor
mouth.
before. He's never been a real prosecutor. What that? Yeah,
Well, it wasn't a real case, so it's kind of the difference.
fair enough.
As a matter of fact, it turns out that unlike anything that has ever happened in American history, so I was right in that regard. I didn't give enough credence, though, to the underlying warnings that were issued to me by former Governor Barnes.
And so the search committee, you said that began with DA Willis took office on January 1st, 2021. Is that correct?
Yes.
And was there outreach to you to be part of the search committee prior to January 2021?
Absolutely.
When did that start?
Sometime after the election, but prior to her taking office.
Okay, so between the election and you're referring to the November 2020 election, is that correct?
Yes, ma'am.
And so when you had conversations with individuals, you said on multiple occasions, you said no, and you turned the position down. Who were those conversations with?
They were mostly with the district attorney.
I'm not objecting right now because we're talking about the process of bringing him on board. But we're headed pretty close to where I'll start objecting once if we start asking about the case and the investigation and stuff. So,
okay, I'm asking about his hiring and being brought on.
Okay.
So you said that you had conversations with DA Willis regarding prior to your appointment as special prosecutor. Is that correct?
Yes, ma'am.
About the role itself. Is that correct?
Yes, ma'am.
Did you have any, I would say, interviews with DA Willis regarding the position?
Define interview. What does this mean?
That means going out late for the night.
How
for
deep
dinner
do you want to go, Joe?
Sliding your foot up her leg,
Midnight phone calls.
like
Lots of cash.
like a job interview where you sat down with DA Willis. She talked about your job qualifications, the role of special prosecutor. You two discussed why you would be best fit for the position. Was there any sort of discussion like that?
It was
Were
more
there
of
any
a
handprints?
It was more of a conversation sort of making me aware of my background and accomplishments, if you will. So if that's an interview, then that's what it was. But it was more of her and her counsel at the time just kind of reminded me, well, you've done this, you've done that, and you've done this. And
You
you've
can
done
back
that.
up.
And
Oh my
they had
god!
to tell him about his background and accomplishments.
Apparently, they're telling about all his positions that he's done.
We know
with.
he's forgetful, so he can't.
I don't
Can
want
I-
to know anything about his positions.
Yeah. Can I just ask? Are we talking about him serving as special prosecutor, or him serving on the search committee?
He
I'm
was
talking about his
searching.
appointment as special prosecutor. Okay. And how many conversations, if you had to quantify, do you believe that you had with DA Willis specifically prior to being hired as special prosecutor?
I have no clue, man.
Was it more than 5? More than 10?
I have no clue. It was a lot.
More than 1?
Absolutely.
Did you have conversations with anyone else besides DA Willis regarding the special prosecutor role and Governor Barnes, I'll say?
I did. And I'm trying to recall if that was blank.
And who's blank?
He's the individual that I had the conversation with prior to my being appointed, if you will, as special prosecutor.
Did he work in DA Willis's office?
At the time, she didn't. She hadn't taken office yet.
Okay, so you spoke with blank prior to DA Willis taking office?
I did.
So this is obviously before he was offered the job. I mean, I keep saying he didn't want the job. He didn't want the job. He's such a freaking liar. Okay, any other individuals besides blank, Governor Barnes, and DA Willis that you had conversations with about the position?
I'm sure there were. I just can't recall who they were.
Okay, I'm going to mark another exhibit. This will be exhibit number 7. This is Judge McAfee's March 15, 2024 order. This is exhibit number 7. To the extent I use this as an exhibit, I'll make sure to refer to a specific page number, but feel free to take time to review it. Are you good to go?
I'm good to go.
And in your opening statement, you referred to distasteful dicta. Is this what you're referring to in this order?
Portions of it, yes, ma'am.
Okay, I want to look specifically at page number 1. You know, that part of the dicta, the sentence starting, among other, and I'll read it into the record. Quote, among other allegations of disqualifying conduct, the defendants contend that the DA obtained a personal stake in the prosecution of this case by financially benefiting from her romantic relationship with Special Assistant District Attorney Nathan Wade, whom she personally hired to lead the state's prosecution team. I'm just wondering if you could help us unpack personally hired. Would you describe that as DA Willis having conversations with you? Did she give you the job offer? Can you help us understand personally hired?
It calls for speculation.
So did you receive a job offer from DA Willis?
If you're asking me to interpret what this judge was meaning when he made those statements, I couldn't do it for you.
So would you say his statement that she personally hired you, is that an inaccurate statement?
Well, you're asking what Nathan's understanding of a judge's order, of a judge's use of the word personally hired. He has no way to know what Judge McAfee meant by that.
I'm asking if he believes that statement is accurate. Is personally hired accurate?
You're asking him.
To your understanding, is it accurate?
Aside from what he wrote in this order, I can tell you that the only person who had the authority to appoint me as special prosecutor was the district attorney of Fulton County, Georgia at the time. That's who had the authority to make the appointment. Aside from whatever the process was, ultimately, she had the authority to do it.
So when you received a job offer or a contract from Fulton County, were those discussions had with DA Willis?
That's too broad of a question. I mean, are you asking about specific things? Are you asking about, because you just said everything?
When you were retained by Fulton County District Attorney's Office, you would agree that you were retained by the Fulton County District Attorney's Office? Is that correct?
I would agree with that.
When you were retained by the Fulton County District Attorney's Office, who did you have conversations with?
I had conversations upon being retained and contracting with the Fulton County District Attorney's Office with blank.
What was blank's role at District Attorney's Office?
I don't know what the exact title he has.
And what did you discuss with blank? Was it just maneuvers of the contract, or what were the specifics?
Of what?
He said that he had conversations with blank regarding his retention. So I'm asking in what regards? Was it about specifics of the contract? Was it about the rate that you would be given per hour?
All of the above.
Okay, and did you have those types of conversations with DA Willis, or were those just held with blank?
Hang on. I just want to be more precise with the questioning because it keeps getting back to this broader question of what's the actual question?
The actual question is he. We just discussed that he had conversations with blank regarding his retention as special prosecutor for Fulton County District Attorney's Office.
But that's just
And he described that he had conversations about the rate. He had discussions with blank about the contract itself. So I'm asking to discuss any of those, his rate and or his contract with DA Willis.
okay.
No.
No. You just had those types of conversations with blank.
That was his job. His job was to sit with me, hammer out the details of the contract, which were this is our contract, this is our rate, sign it. So there you go.
And the judge's order, it states that you were personally hired to lead the state prosecution team. Is that accurate to describe you as the lead for the prosecution team?
Yes, that's accurate.
Did you have any discussions with DA Willis regarding you leading the prosecution team?
That's what she hired me to do.
Beyond just explaining that you would lead the prosecution team, were there any more details provided, like how many employees you would supervise, if you would lead a team of prosecutors, if you would have office space in Fulton County District Attorney's Office? Were there any of those types of conversations?
So there's a contract that's in the public sphere, and that I'm just going to ask at the four corners of the document control, of that document control. The contract speaks for itself. If you don't have it, I could ask my counsel to provide another copy of it to you. I know that it was provided in some discovery responses, and it was a copy of the actual contract that was excluded. Executed, yeah, sorry. So whatever those details are, it's in there.
And prior to the contract being sent to you, you discussing it with blank. I believe you said his last name was. Is that correct? Did you have any discussions with DA Willis or what the job would entail?
It's all in the contract.
Did you lead a team of prosecutors at the Fulton County District Attorney's Office?
I did.
How many were on your team?
So let me say this. Those men and women, many of which are not known to the public, there's some safety concerns there. And I don't think we should really be talking about.
She didn't ask names.
Am I responding to you or him? Which?
What a dick.
Hey, Joe. Joe, I'm sorry to interrupt, but I got to go.
All right,
guys, it was great hanging out with you.
Later.
You're doing a great job. Keep doing a great job. It's really a great show. Joe, I'll talk to you soon.
Looking forward. Take care, my brother. Thanks.
Take care, Marco.
I appreciate that. The great Andrew Branca. He'll just help out with the objections. I'm sorry, this is deposition. I think under deposition rules, only one counsel is allowed to ask questions. I didn't ask a question. I just confirmed that she did not ask names. I think that's a violation of the rules. Obviously, you guys are in charge, so you can do whatever you want. But it's not a violation of the rules. It's just confirming she did not ask for names.
So let me say there was a team, and there was more than one.
There was more than one. Did you supervise a team of more than 5 individuals?
Yes.
More than 10?
No.
Okay, so it's between 5 and 10. Is that correct?
That's correct.
And were those individuals all barred attorneys?
No.
Okay, and can you give us a sense of were the individuals paralegals, secretaries, assistants? What did that look like for individuals who were not barred attorneys?
All of the above.
Okay, how many individuals would you say were barred attorneys? More than 5?
I believe, yes.
Okay, and I want to ask you a little bit about the organizational structure. So there.
Are we talking about the Trump case, or are we talking about just overall the district attorney's office?
I'm talking about just for the case against President Donald Trump. That was our understanding, is that you were hired specifically to be special prosecutor on the case against President Donald Trump. Is that correct? There were no other cases that you worked on?
That's not correct.
Okay, so you worked on other cases other than just the prosecution investigation of President Trump?
Yes.
How many other cases did you work on?
I don't know.
What type of cases were they?
Criminal cases.
Criminal cases. What types of crimes?
I don't recall.
Were they all in a specific unit, division, district attorney's office, like the anti-corruption unit? Were they all in that vein? They were on Vice Squad. What the hell are you prosecuting here, doofus?
No, ma'am.
Okay, and so talking specifically about the investigation, prosecution of President Trump, how many attorneys did you supervise?
Now we're starting to get into the actual investigation. And this is where I'll start objecting.
Oh, Jesus.
I don't mind about he was interviewed to do a job. I don't even mind about how many barred attorneys were working. But now we're starting to get in specifics about the investigation. And that's where I'm going to object under privilege and stuff. I don't want to talk about the structure of anything that has to do with the case or the investigation of. And Barnes says, and I don't want to get down to the specifics that even though names are not used, that you can identify people. I mean, you don't know how bad this has become since President Trump has brought this out public and Chairman Jordan to the extent of having to move out of their houses. So with that admonition, then you can go ahead.
So you said you supervised a team that was between 5 and 10 individuals. Is that correct?
Yes.
And so with those, even though you know, I believe under the contract, you were limited to 60 hours per month. Is that correct to your recollection?
I don't recall, but it was something, it was awful.
And you know, I believe DA Willis and you have both publicly said that you worked more hours than you billed for. Is that correct?
Absolutely.
So when you were working for the DA's office, you also had your private law practice as well. So I just want to specifically focus on your work for the DA's office. So you supervised a team of 5-10 people. Did those individuals reach out to you for guidance? I'm not asking for the specific guidance you provided, but would they reach out to you and take direction from you?
What's meant by guidance?
Can we interview this individual as an example?
That's too broad of a question. He's not going to know.
Would the individuals that you supervise, would they ever contact you? We'll start with that.
Well, I'm just going to object to this whole line under, I mean, this would all be covered under attorney work product, under attorney-client privilege. I mean, there's still ongoing investigation in addition to the Court of Appeals decision about the motion to disqualify. So we've got several different problems here with confidentiality, and even disclosing, the broad architecture of how the structure was and who's communicating with who, and even without getting into the granular details about all that. So I'm just going to continue to assert that these objections under all these privileges.
So how would discussing the structure of the office, how would that affect the investigation?
Because it's, as Governor Barnes said, you start to limit this to a universe of people that could be identified. Even just saying 5 to 10 barred attorneys, you could start getting people back.
That's crap. This is such a crap objection.
Why would that matter?
People, yeah.
It's such a crap objection.
The records and trying to figure out who these attorneys are so they could be a subject of, verbal attacks or whatever. So, I mean, I don't want to give anything that would put anybody in jeopardy for that.
And how would whether conversations occur between him and the individuals they supervise be covered under the attorney-client privilege?
Because you're starting to get into, when you say 5 to 10 barred attorneys, and then you have to start asking questions about, did any of these people tell you who to talk to and stuff? And you're just going to get into without specific knowledge. And if they could be identified, there'd be an absolute reason to go after certain people.
Yeah, and I'll state that I tried to start out broad, and you objected to the question. I tried to say, did anyone from your team reach out for guidance?
It's not a perfect science what we're doing. I get it. I was just trying to give some leeway with some questions about the process of hiring him and stuff like that. But even, tied to the investigation, so keep in mind that this is a 2-year investigation. It's still going on. So it got put on hold by the Court of Appeals while they review the order of the motion to disqualify, but it's still going on. So we've just got all these people that are working in the office that are still a part of all this. Nathan's not a part of this case anymore since he resigned, but all these people still are. So there's a lot to protect here. No, not just with this, but with the ongoing investigation.
Since this is about grant money, why don't we get down to it? You were paid this. Do you know if this came from federal funds? I mean, what is this beyond the scope of the subpoena? I'm trying to get this, sir, but we have to lay the groundwork first if it's hiring a special prosecutor.
Why don't you just ask him? Sorry, go ahead. Why don't you just ask him if he knows anything about the grant money, about how he was paid?
We'll get there.
Well, but why do we have to run the risk of narrowing down the number of people? I don't think you fully understand these nuts and how violent they can become. And so, just ask the question.
And you'll permit me to. I'll go ahead and get back to questioning, so we'll restart the clock. So did you have an office space in the Fulton County District Attorney's office?
Did I have a place where I went to complete the work that I was contracted to do with the Fulton County District Attorney's office?
That's correct, sir.
Yes.
And was that at the physical address of the Fulton County District Attorney's Office?
I cannot, for safety reasons, disclose where that office was.
Why? You're not there anymore. That's ridiculous. Okay. I'm not asking for the specific address, but you had a desk somewhere where you completed your Fulton County District Attorney's Office work. Is that correct?
Someplace.
Someplace. And did you have an official email address with Fulton County?
No.
One of us is buzzing. I'm not sure who it is. I think it might be you, Stephen. Can you mute yourself for a second, Stephen?
Oh, I was muted. Yeah, I'll do it again.
You were muted?
Yeah, I'll mute right now.
All right, I don't hear it anymore. So, I don't know. No, now I do hear it.
Okay, sorry. Let me turn myself down a bit.
Is it? You think it's you? I don't know. All right. So if someone needs to reach out to you regarding your work with the Fulton County DA's office, would they email you on the regular Nathan J. Wade Law for Office address?
They would email a legal assistant, a paralegal, or one of the other full-time team members to get to me.
Hold on 1 second. I need to check something up here. Have this proper. All right, fine. Okay, and did you have a business card with Fulton County DA's office that identified you as a special prosecutor?
I did.
And did you have a government phone or phone number where you could be reached to discuss Fulton County business?
I did not.
You did not. So with this similar process...
See, even that's getting too close because we're starting to ask whether people are using their personal cell numbers to conduct business with Fulton County. I object to that because that could potentially reveal an identity of people.
That's ridiculous.
Keep in mind, he had to change his phone number like after some of this went on. So this is not just academic objections.
Of course it is.
This is real life stuff that has been a lot of threats and people have faced.
Yeah. Well, what this line of question is trying to get is how integrated into the Fulton County District Attorney's Office were you?
I don't understand the relevancy of that.
Relevancy is not a proper objection. Sorry, go on.
We know we had a contract with them. It's not disputed that he was a special prosecutor on this case. What's the difference? What difference does it make when he worked on, or what phone number he had or anything? I don't understand.
So I'll just ask a broad question then. Did you feel like you were integrated into the day-to-day operations of the Fulton County District Attorney's Office?
What does integrated mean?
What, you don't understand what the word integrated means? Oh, no, sorry. This is so stupid. It's like, I'm trying to detail that by asking whether you have phone numbers and email addresses and your lawyer isn't letting you answer. You're just like, what does integrated mean? This is the stupidest thing in the world. This is such shady freaking freaks. All right. So I'll just ask a broad question then. Did people know who you were? Did people interact with you on a daily basis?
Most people did not know who I was.
Okay, just the individuals who were you supervising your team. They obviously knew who you were. But other individuals at Fulton County DA's office did not know who you were?
Most other individuals at the Fulton County District Attorney's Office did not know my roles, nor have any knowledge of the work that I was performing.
And prior to your appointment as special prosecutor, you listed in your opening statement and in the first few of my question roles where you were a prosecuting attorney. Is that correct?
Yes, ma'am.
Prior to your appointment as special prosecutor, have you ever worked in a district attorney's office?
No.
And in your opening statement, you mentioned various criminal cases that you worked on regarding, whether it was the capital cases, murder cases. Have you ever worked on a RICO case or racketeering case?
Okay. So when you say worked on, are you meaning tried? Because the cases that I mentioned were cases that I actually tried.
Okay, so we can take it a step back. Have you ever just worked on, not you being the attorney of record of the case for a RICO case?
Are you asking if I ever participated in the prosecution of a RICO case?
Correct.
The answer is no.
No. So this was the first case you were prosecuting a RICO case?
Yes.
And how did you get up to speed on the contours? Obviously, RICO is a complex law. Not talking about while you were on the job, but prior to taking the position on, did you study any of the RICO law? Evans?
Sorry, I was reading
right.
chat about all the buzzing. I would just say that the last clarification is what I was going for. That if you could talk about what you did to learn about the law, like the law itself, what RICO as a count means, what I don't want anything.
I absolutely did. I went to what I would call RICO school to learn about what it is, what it means, and how it works. It's a very complicated legal concept, but the dubbed godfather of RICO, the gentleman who wrote the book, spent hours and hours teaching me RICO, if you will.
And beyond that, did you do any other study to prepare yourself for taking on the position of special prosecutor?
I don't know there's anything greater than sitting at the foot of the person who has written the book on a legal concept. There's nothing better than that.
And who are you referring to when you say he wrote the RICO book?
John Floyd.
John Floyd. I think that's Fanny's father, right?
Is it?
No.
Isn't his name Floyd?
There was two Floyds in the case, the Trump case's witnesses. One relation, one one not. And that's the only name I want to have you give. And that's the reason I didn't object there, is because he's already part of the public record, but that's okay.
And did Mr. Floyd work for the Fulton County District Attorney's Office, or did you just seek him out?
I don't know who he works for.
Okay, so he wasn't contracted by the District Attorney's Office to your knowledge.
That's not the same question.
No, it's not the same question.
And the answer is it's public record that he was.
And had been for years, from time to time, by the predecessor DA. So how did you go about contracting Mr. Floyd?
He was teaching a RICO course, and I went to the course.
I'm going to try and boost your volume here. So let me do that. You stay your settings the way you have them. Don't change that, because I'm getting buzz back when you try changing them. But I'm going to try and edit your mic settings to jack you up.
Okay.
Okay. During your time as special prosecutor at Fulton County District Attorney's Office, did anyone supervise you?
What does that mean, supervise me?
Was there any, if there was an organizational chart, was there anyone above you?
I object to that on the same grounds that we're talking about before, that we're getting too far into architecture and structure and, stuff that pertains to the case itself, so I don't.
In your role as special prosecutor, did you report directly to DA Willis?
You don't have to answer that if you don't want to.
What's the objection? What's the privilege?
Again, it's just, first of all, I don't see the relevancy to any...
Not a valid objection. Go on.
With the grant funds. I don't see the relevancy of anything to do stated in the committee's letter about oversight of removal to federal court stuff. So I find this whole line of questioning irrelevant. But I want to go back to the original objections of we're just getting too much confidential material with the structure. Who he's reporting to, who he's working for, who,
he didn't ask
all
that
this
name.
kind of stuff. It's just not anything he's going to answer.
And what's the privilege? You didn't state a privilege. Well,
the privileges, there's several privileges. I mean, there's just general attorney work product privilege that deals with confidential information.
That's crap.
There's attorney-client privilege generally, which is going to cover it.
Nope.
There's grand jury secrecy provisions, which will which are talking about confidentiality in the process of everything.
Not a thing.
We've got Georgia Bar Rule of Professional Conduct.
Kevin.
Huh?
You got loud all of a sudden. Sorry. You're buzzing.
Am I still buzzing?
No, you're not. Now you're good.
Okay. I think it was my phone. Sorry.
All right. Good.
Conduct 1.6. There's just a general rule of confidentiality anyway. So we've got a multitude of privileges.
None of them actually exist. And how does whether DA Willis supervised him fit into those privileges? It's just yes or no answer.
The contract that he has with Fulton County is public record. None of the rest of the stuff is public record. So you're just asking for stuff about how it all works. So whatever DA Willis decided was the hierarchy and how communication was going to get passed and who was going to be supervised by who. That's all attorney-client privilege
no,
to
it's
me
not.
because that's confidential material on how the office operates.
And that wasn't my question. It was, did DA Willis supervise him? That's a yes or no answer. So how would that lead to the reporting structure that DA Willis had set up?
Because I don't know what supervise means. They have conversations, but I don't feel that he's at liberty to discuss some kind of rigid hierarchy for how information is communicated within the office. That's my objection.
So we can take it broader if that would make you feel more comfortable. You see, they keep backing down to his ridiculous crap, and that's why he keeps throwing more ridiculous crap. They're rewarding, and just to let you all know what's happening here, he's making bogus, stupid, empty, ridiculous objections. There's no attorney-client privilege here. There's no grand jury privilege here. None of this is actual privileges. But when this guy, or whoever is asking questions that I'm reading for, it backs down and says, okay, well, let me try working it this way. He's basically displaying, you can bully me with BS objections, and I'll try and thwart the direction that I want to go in here, or raise relevancy, which is not ever a valid objection in any sort of deposition format, especially not here where they have broader privileges than in normal deposition. So this whole thing is just, it's kind of pathetic to read. I'm not going to kid you. It's a little frustrating to me. Let me get to Nicole here saying, I don't want to interrupt this greatness and role playing, but it's officially my birthday. May I get a little happy birthday shout out? Thanks so much. Happy birthday, Nicole! From 2024. Happy birthday. I hope it's an amazing day and year for you. And hopefully that the year starts off with an awesome bang over the next few weeks for you. All right. So we take a broad up that make you feel more comfortable. Did anyone oversee you in your position as special prosecutor?
Well, that's the first question I objected to. The second one was, when did Fani Willis oversee you? So I don't understand.
You don't need to understand, you jackass. So how do we not know what the word supervise means?
What are we trying to get here, though? I don't understand,
Look, we ask the questions. I mean,
yeah.
Sometimes when you ask a question, as you know, it leads to other things. But I mean, we're objecting here to the meaning of the word supervisor.
No, I'm objecting to the conversation as it was explaining about just getting how information is passed within an office on a case that is subject to grand jury secrecy laws, a case that's subject to.
I didn't ask how information is passed. I asked who. Did anyone oversee Mr. Wood in his position as special prosecutor? That's not how information is passed. It's just, did someone oversee you? Yes or no? Did DA Willis? Was it the criminal division? Was it deputy DA? Was it?
We're still getting into too many names and identifiable people.
And to make you more comfortable with the question, that's why I took it back and did anyone ever oversee you in your role as special prosecutor?
Okay, you can answer that question. Did anyone ever oversee you?
No.
So you had ultimate authority in the case, you would say?
Yes.
I mean, I would object that calls for speculation generally, but...
yeah, folks, I'm an old man. Eventually, we're going to have to go to the bathroom. Hey, we're at minute 51. Can you wait just for 9 minutes? Oh, okay, I can make it. So, Mr. Wade, it's a matter of public record. You were paid. You received for your services somewhere a little bit over $700,000. And I understand from your testimony at the hearing that there was a structure where it went to a joint account between you and your law partners, paid expenses, and then it was divided among the three of you. But it's accurate to say that you were reimbursed, not you, your law firm, your partnership, was reimbursed $700,000 for your services, a little bit over that.
Reimbursed?
In payment for your service that you provided to Fulton County District Attorney, you received $250 per hour. Is that correct? That was your rate?
That was not my rate. No, ma'am. But again, the contract is going to control.
Uh-huh.
So whatever the contract says, that's what it was.
The objection I would have is just on that one, the form of the question. The question was asked at the hearing, and there's about a 30-minute discussion about what it meant, what the word law firm meant.
Correct.
Because he's had 4 iterations of partnerships and everything. So I would just ask for...
Yes, I was just attempting to truncate it here for the record. I understand that you yourself did not receive the full payment. Is that correct?
That's correct.
And that it was divided among, after expenses were paid, it was divided between you, Mr. Bradley, and Mr. Campbell. Is that correct?
That's correct.
And at some point, Mr. Bradley and Mr. Campbell also had contracts with Fulton County District Attorney's Office for first appearances and or filter or taint review, I believe it's called. Is that correct?
That's correct.
Do you have an understanding of when they were contacted of when they were contacted regarding, negotiating those contracts, or you brought on to do the first appearances, taint and filter review?
I do not.
Were you ever involved in the first appearance contract?
I was not.
Were you ever involved in the filter or taint contract?
I was not.
Do you have an understanding of when those contracts ended specifically?
I do not.
And was the payment structure similar to how your payment from the Fulton County DA's office was received? It went into a joint account, expenses were paid, the remainder was divided among the three of you.
Well, it would go into an account,
Uh-huh.
and then the way you explained it would happen.
Okay.
So not necessarily a joint account.
And DA Willis?
I just want to make sure. Were you aware that Judge McAfee has a YouTube channel that recorded the hearing?
Correct. And I watched his testimony, and I watched DA Willis' testimony, Mr. Bradley's testimony, Mr. Yurdy's, Miss Yurdy's testimony. I watched all of that.
Right. So these questions, specific questions, have been asked and answered.
Under oath.
Under oath.
And as Blank said, sometimes responses elicit additional questions or new information.
Well,
so that's what we're just asking questions here.
Right. So I didn't object to some of the other questions that were asked at the hearing tangentially, but these actually have been asked and answered.
And what would the privilege be then if they've already been answered?
We keep pigeonholing this into privilege. I mean, I've already said that I don't recognize that as a limitation, but I would object just generally under the common law deposition rules or just the general deposition rules of everything of just asked and answered and just not wanting these things happened a long time ago. What I'm concerned is that he might say something that would be inconsistent with the testimony that he gave to the hearing.
Yeah,
might
where
cause
he
a
lied his
problem.
ass off.
Not because he's trying to mislead or anything,
Oh, of course not.
but just because he just doesn't remember. And so I
Uh-huh.
don't want him to answer the questions.
Well, if he doesn't remember questions, if he doesn't remember something, he can tell us.
He can say that, but we're getting into questions that I've already been specifically asked.
And we're not going to. Blank is not going through every question that has been asked. I'll also point out this is still on appeal, this issue.
It is.
We're ready to go back. Okay. Were you the only special prosecutor, to your knowledge, that was contacted to work on the case against President Trump? Are we good to go? Yeah, I was just asking if you would just tell us when you pause your timer so we can keep track of time. To your knowledge, were there other special prosecutors beside yourself that were contracted to work on the case against President Trump and his co-defendants?
Yes.
And how many others were there?
At least two.
And were their roles similar to yours?
No.
How did their roles differ?
They weren't required to spend the amount of time that I was required to spend on this case. They were more as needed.
And when you say that the time you're required to spend on the case, what do you mean by required?
Well, your earlier question probably 30 minutes ago dealt with RICO and my understanding of the legal concept of RICO. Well, in order to be certain that I can could fully understand the concept, I was required to go through the training. I was required to make certain that I understood how to apply each and every element per the statute. I was required to, and I'm trying to answer your question, without going into now investigative processes, but we had different requirements.
And do you have any knowledge of or a reason to believe that Fulton County District Attorney's Office paid you with federally derived funds?
So that's some kind of misconception that the Fulton County District Attorney's Office paid me anything. Why? Is that your next question? Why?
Sure. Go ahead, sir.
I'll answer it. I would submit an invoice, many of which you've seen, probably all of which you have. I would submit an invoice, and 3 to 5 or so months later, I would receive a physical check from the Fulton County Board of Commissioners. That's who paid me. So the Fulton County District Attorney's Office never wrote me a check. They didn't pay me a dime. But the Fulton County Board of Commissioners did.
Who gives a crap? That's the stupidest. Okay. And when you received the check from the Board of Commissioners, did you ever have knowledge of the reason to believe that those funds were derived from federal funds?
I have no clue where they got the money. I was just more, I guess, astonished in the fact that it took me 3 to 5 or 6 months to get it.
And we'll talk about the invoices in the next round, so we'll go back to that. But the practice was you would track your time, put it in an invoice, and then would you send that to the Board of Commissioners or send that to the Fulton County District Attorney's Office?
I would send it to the payroll department within the Fulton County District Attorney's Office, and they would then do whatever they needed to do with it. Sometimes it would be, what does this mean, or what does that mean? I would then go into my investigative file, look through my investigative notes, and clarify whatever it was I needed to clarify. And then they would then do whatever they needed to do with it within that 3 to 5 to 6 month period, and I would get a physical check.
The reason they needed clarification is because he is the worst block biller I've ever seen in my life. It's comically bad billing. When you're hired, and this is part of what made it seem as if he was not being scrutinized at all for the payments he was receiving, and why it looked like he was being paid by a lover, not a boss. Because anyone who's a boss would be like, this is crap, I'm not paying this. Only someone who's really looking out for you would be like, oh, okay, this crap billing is something that I'm going to pay. Because you're talking about attorney-client privilege. Yeah, it's technically true. Fulton County is his client in this scenario. And a client demands to know what the hell you were doing for 8 hours, not just say research or whatever, 8 hours research, because that could literally mean anything. And it doesn't, and you can just make up whatever number you want. And he would max out the number of hours in a day, say research, or 6 hours drafting. And it's like, you have to, if you're going to get paid by a client who's actually, arm's length transaction rather than a lover paying you, in that case, you have to say that you spent 2.3 hours drafting your indictment charges, and another 0.4 of an hour researching this particular element and what it is that you're looking for, perhaps even referencing a couple cases that you found that as a result of that research, and then another 1.7 hours, not 8 hours of drafting, research, court. You have to say what you were doing, why you were there, what the purpose is, and that's how you get paid. And it's never exactly 8 hours. Never. Now, he might say, well, I can only bill 8 hours in a day. I was really working 14 hours. I don't know, but sometimes he actually charged for 14 hours in a day. So it's like, it was the most ridiculous thing in the world. So when he's saying he had to explain it, I would assume that he has to explain it to someone, because the only person who would sign off on someone like this is literally someone who he was in bed with. Literally in bed with would be like, oh yeah, sure, I'll sign off on that, because no one else would. No client ever would in an arm's length deal. And that's part of why there's an investigation going on here. That's part of why this whole thing blew up on them the way it did. And when you said that if they had questions about something, you would go check your investigative file, would those questions come from individuals in the payroll office?
I don't know where they came from. The questions would come from the email, and it was like a general Fulton County email that it would go to. And then they would bounce back a question surrounding entry whatever. And then I would then check the file of the notes, the investigative file of notes, and hit reply and respond to the inquiry.
If your invoice total was $2,000, I know it's probably low, but if it was for $2,000, would you paid out $2,000?
Sometimes.
And when you say sometimes, were there sometimes questions regarding the invoices, or you weren't getting reimbursed for all the hours you noted in the invoice?
When I say sometimes, I mean sometimes the invoice was $2,000, to use your example, and I was paid $1,500.
Okay, we're at an hour, so we'll go off the record. All right, so let's pause here for a minute, because I sort of want to take like a little break here. I'm actually thinking we're at the 2 hour mark. Let me see something here. Let me just pause and see. Is this the full 132 pages? Yeah, it's a full 132. A lot of times at the bottom of these depositions, they'll have like a word count type of thing, and that'll eat up like 30 pages. But this is a full. We're really at the halfway point here. Okay, and I'm 2 hours in, so I think I'm going to stop. I think we're gonna stop here, because this is. And I just want to applaud both of you for the phenomenal work that you did. Let me get to this question here first from Shiloh, who's asking: was that why Bradley was such a pain in the ass while he was testifying money lost. Didn't they also say the partnership was dissolved by then? I think that I don't think that had to do with their block billing. I don't think it had anything to do with that. I would imagine that from what I recall, the conversations and issues that they had with Bradley seemed to be unrelated to stuff that they were testifying about. But I'm thinking back, to February, and we're now in October, so it's 8 months. So I'm not I don't recall exactly what it was that he said, but my recollection was that it really was probably unrelated to this, because I have a feeling he was bringing more bank from this to the firm than he did in anything else he was doing. So, yeah, that's the best I can answer that question. You guys have any thoughts about what we've seen so far?
No.
I mean, this, just from reading, this guy strikes me as like he thinks that he is smarter than everyone and is somehow getting one over on them, but totally is not, and is not catching on.
Yeah, on anyone. He comes across like he thinks he's the stupidest person in the room who happens to think that he's the smartest person in the room. That's literally there's a certain hubris and tone of like superiority. Like that makes you the most qualified person. I didn't even want to take the job and like whatever. And then and trying to doctor his sincerity with I was too naive. I didn't catch on to what Barnes was saying. That's one thing I missed that he was saying. But basically saying, I studied at the foot of the master. That makes me the best person for the job. And I didn't want the job, even though before he got the job, he was researching how to get, what steps to take for the job. So it's like, you don't research what steps you need to handle a job that you have no intention of taking. So
it's like any government contract. You already know who you're going to award it to, but you just go through the motions of getting quotes, and doing interviews.
That's a great point. That it's a government contract, and they know
you got to check the boxes.
Yeah. So you go to a Roy Barnes,
but it's like he's like on one hand like trying to act like fake humble, like poor me or whatever.
Yeah.
I'm not worthy. But then he's doing this thing, and it reminds me of
But then talk about how highly qualified he is, and he's got so much experience in speeding tickets.
Yeah. he's doing it. He's reminding me a lot of the record keeper with the merchant case, where like if I can just parse every word in a sentence, then I win somehow.
Yes. Yeah. If I can seem like I'm technically checking off the right boxes, then I'm okay, even though nothing I'm saying actually seems reasonable, logical, or what anyone normal in this situation would do. Yeah.
Or have any content whatsoever.
Yeah. That's a great call. It's like this entire office is just sort of like really effed up. They're like they're really messed up place. This is like this seems like such a toxic environment. These are not people who are actually, and then they stand up there saying how they're looking for justice and everyone has to answer to justice.
And they have to, and to even bring up at this point, like, no political bias, and even still bringing up like, oh, there's threats of violence. It's like, going one way, dude.
Yeah. It's not a joke. It's
even not catch that. It's just like the how far this guy's head is up his own ass is astounding.
Think I kind of disagree with DES. I'm wondering whether you think he knows that he's DEI. Because I don't think he thinks himself as DEI. I think he thinks himself as like the that he's. I don't think he thinks himself as being DEI. I think he thinks himself as being very capable.
Yeah, I think he just believes he has what it takes to do the job, and that he's the best there is. And so,
yeah, I think he's just not letting the evidence of the world get in the way of what he wants to believe. I mean, isn't he like broke too? And clearly the facts are not in his favor.
I mean, it's divorced, yes.
And I think that the reason he probably thinks he's the most qualified is because he's down with the agenda of let's persecute Trump. Yeah. So, that's which they can't admit that that's what the agenda is, but that obviously is the case.
Well, and everyone in the county anytime they're testifying, they never answer the questions. They're always going around and around. The guy that we talked about at the beginning that wouldn't give
Bond.
Merchant her stuff. And,
Yeah, Mr. Bond. Yeah.
And Bond. And it's just, I guess
It's so exhausting.
if you're
It's so exhausting to listen
you're-
to them.
not doing anything wrong, it's easy to answer questions. But when you
Right.
know you're doing the wrong thing, you
Right.
won't answer.
Yeah.
But it also is just, I mean, it almost seems like kind of a feedback loop, because it's like nothing ever happens to these people. Like between this, the records case, and watching how they're handling the YSL case, they mess up all the time, and they're like, don't do that again, but then nothing ever happens. So why would they ever change?
I had missed this Allegan news. I'm sorry. I apologize for that. Yeah.
Well, and that's YSL is not why they're getting any death threats or security reasons. It's only the Trump case.
Yeah. Yeah.
If that's even happening, they could just be saying that.
I know. But
Yeah,
it's
it's
just,
like, who,
we got this giant RICO against the YSL crew.
I mean,
and
I think it's
we got
possible.
Trump, and
I think it's possible that there are a couple lunatics out there who issued death threats.
Oh, sure.
I think it's
Yeah.
possible.
there's always random nut jobs.
Yeah.
you find and prosecute them, because most of the time they don't hide their identity. They just call from their own cell phone or
They're too
send
stupid.
from their email
Yeah.
address with their name on it. So it's like,
Right. All right. Well, I want to thank both of you for popping in here. I'm going to try and look ahead and see whether I think that this has. I'm going to try and review this and tell the audience. I'm going to try and review this over the next day and see whether we're going to proceed. I'm going to proceed further, and if so, let's look into availability of various people to come in here. And keep you apprised on that. But I want to thank both of you again. You guys were phenomenal. They're really, really great. And just jumped in here last second. And yeah, you see, I probably need even a couple more people, because I have Steven playing multiple roles. I'm reading multiple parts. We're jumping around here. But you guys were phenomenal. So everyone at home, give these guys a big round of applause. Phenomenal job, Kevin and Steven.
Well, thank you, man.
And yeah, I'm gonna wrap up this show over here. I want to thank you all for joining me, and God willing, I'll be back here tomorrow evening. Again, not sure whether I'm going to continue with part 2 here or not. I am going to put a link to this deposition. Those of you who want to read the rest of it, in case I don't end up getting to the rest of it. I would say it's like 50-50, but I'm going to go the rest of the way with this tomorrow evening. So, but I'm going to put a link to this in locals at goodlogic.locals.com. That's goodlogic.locals.com. While you're here, please make sure you like, subscribe, do all that other stuff. I don't think I've shown my little cartoon guy here in a really long time, but he's going to smack Steven in a second, run up there and smack him. So, yeah, but if you can all make sure you hit like and subscribe, drop a comment, and whether you think that they sounded that had any credibility. And yeah, that's it. That's our show for tonight. And again, thank you guys. You were really amazing.
Yeah, thank you so much, man. Glad to be here.
What do we tell the audience before we go?
Don't
2
eat
things.
the bugs.
Well, first, before that, stay away from all the lab meat. And right, like Kevin just said, don't eat the bugs. Have a good night, y'all. And as always, Godspeed.
good night.